And I'm an attorney here in Scottsbluff. I practice with the law firm of Klein Williams Wright Johnson and Oldfather, and I manage our Scottsbluff office for that firm. For a lot of years, I spent a great deal of my practice serving as a guardian ad litem in a lot of very interesting and many times tragic juvenile cases. And then, thank you, Kelly. And then when my husband and I had our first son, I decided I was going to do a little less work with other people's kids and work with mine instead. So I still do some guardian ad litem work, but not as much as I used to do. And I was very pleased to be asked by Kelly to do the Nebraska case law update for you. I do have a funny story for you, though. Just in case you wonder whether everybody else in the world knows about the kind of work that we do, they don't. I stopped at my office at noon to check the mail, and I was talking to a fellow tenant who looked down and said, "Oh, you must be at a conference today." And she read my name tag, and then she got a really confused look on her face, and she said, "What kind of conference are you at where you have to tell everyone that you're a gal?" I'm not making that up. She really did say that. Okay, when Linda was talking earlier, she had everybody raise their hands, and we all know there's a good group of folks here today who are lawyers and judges and involved in this process from the judicial or legal side, and then there are a whole lot of folks here who are in the trenches, day to day, working with these families. CASA, social workers, caseworkers, all of those folks. And to the folks who are in the trenches, who don't do the legal procedure, but who are working with these folks every day, I hope that you won't zone out for this case law update, because there are some cases that I selected today that I selected specifically because they give lawyers and judges critical pointers about what we're supposed to be doing and what happens to us when we do it wrong. But there are also a lot of cases that illustrate how important it is for us to get the right evidence in front of the judge. And the people that we rely on as legal practitioners to provide that evidence are those of you who are working with these families on a daily basis. So when we get to those kinds of cases, if you've tuned out because I was talking about something like judicial notice, tune back in, because we need you to give us the evidence that's required to help protect these kids, okay? Now, in your materials, you have a Nebraska case law update sheet. The best I could do for you, since they slotted me at 3 o'clock when everybody's on a sugar low and you've been here all day, the most I could do for you was not condense these cases into little tiny print and put them up on a PowerPoint slide. So take a look at that. So take a look at that. We're going to go through these cases kind of case by case. I'll give you a summary of the facts. And what I think, at least as I reviewed the cases, is relevant to all of us in this room who are working with these kids and these families. The first case that I have mentioned there is in the in re interest of Jorge O. And this case is a really narrow case, but what it talks about is the fact that the juvenile court was dealing with 2 juveniles who were placed with YRTC in Kearney and placed in the custody, of course, of the OJS. The juvenile court judge ordered that the court itself, rather than OJS, would decide when these juveniles could be released from YRTC. On appeal, the Court of Appeals, the Nebraska Supreme Court ruled that that's not a decision that the juvenile court gets to make. Juvenile courts have a lot of discretion in these cases, but once custody is remanded to the OJS for placement in some place like the YRTC, the OJS gets to decide when these kids are doing well enough to be discharged. The next case is Gabriella H. And this is a pretty interesting case too. And I bet y'all recognize what circumstances led to this. Gabriella's biological mother got a little tired of Gabriella when she was 11 and left her at an Omaha hospital. And we all know about the law that let her do that. A juvenile petition was filed, and Gabriella was eventually adjudicated as a 3A case. The juvenile court had placed temporary custody with DHHS, with the department, and then decided at a later dispositional hearing that there was no point in doing any more reasonable efforts with this family because mom and dad wanted to relinquish, they did not want to be reunified, and it was sort of pointless to try and keep pushing that relationship when mom and dad were saying, "We don't want her back," which is a hard thing for any kid to hear, but we don't want you back, we don't want you as part of our family, and we want to voluntarily relinquish. The legal folks involved in the system all agreed that the best thing to do would be to take their voluntary relinquishments and look for placement. So This was looked at by the State Foster Care Review Board, by the guardian ad litem, by the county attorney. All of those folks said, yep, this is the right thing to do. We should change the permanency goal from reunification to adoption and get this case moving so this child gets some permanency. The department, however, in this case, refused to take the voluntary relinquishment, and in part refused to take that relinquishment because during the juvenile court proceeding, the juvenile court judge had ordered the biological mom to pay some substantial child support, which she was doing. So she was at least being financially responsible for the child, even though the child was not placed with her. The juvenile court said, thank you for your input, department, but I'm going to order you to take these parents' voluntary relinquishments. The department appealed that decision, and on appeal said, we as the department, under the statutes, we're the only ones who get to decide when we take a voluntary relinquishment. The court can't order us to do that. The Nebraska Supreme Court disagreed, and when the Supreme Court disagrees with you, you lose. That's the way that works. And they said, you know, yes, the department has discretion, absolutely. But that discretion is always subject to the juvenile court's discretion to determine what is in the best interest of any given child. And then in what, you know, for lawyers who read this stuff is sort of a dryly sarcastic statement, the Supreme Court said, it is clear from the record that DHHS declined to accept the relinquishment of parental rights because one of the parents was paying a pretty substantial amount of child support, which partially offset the department's cost with respect to Gabriella's care. While conservation of public resources is a worthy objective, it cannot justify the legal perpetuation of a parental relationship which no longer exists in fact, thereby permitting an abandoned child to linger indefinitely in foster care. We agree with the observation of the juvenile court that the position taken by the department has made Gabriella a de facto orphan. You know, so if you need some language at some point that reminds us all how critical, how mission critical permanency for the child is, this is the kind of language you look at. Now, I did note another case down there at the bottom, which is in re interest of Cornelius K., in which the Supreme Court further addressed this issue and said, absolutely, as we said before, the juvenile court gets to decide when a voluntary relinquishment must be accepted by the department. But procedurally, you can't do that relinquishment at least until after you have an adjudication, which makes sense, and a permanency plan that's been established. So those are the precursors. Another very big case this year is in re interest of Emma J. And this is a really big case for a couple of reasons. For those of us who are practitioners, it is a clarification and a warning, both. Emma J. involved a young girl whose mother and father had been subject to prior juvenile court adjudications related to two other daughters. And in each of those instances, the adjudications or the juvenile proceedings previously had to do with inappropriate physical discipline and a variety of issues like that. In Emma J.'s case, a petition was filed because the allegation was that, again, she also was being subject to inappropriate discipline. The issues that her older siblings had hadn't been resolved. Her dad was physically and verbally abusive to her, was demanding that she have an abortion even though he didn't actually know whether or not she was pregnant. Nobody had ever told him that she was, but he was pretty sure she must be. And so she was in kind of a difficult family situation. This also was an ICWA case, and you know, all of those of us who work in this area, you know, ICWA's always fun. So, the juvenile court concluded that the state had proved by clear and convincing evidence, which for those of you who don't do this all the time, that's the middle standard of proof. You've got by a preponderance of the evidence, which is the easiest level to attain, you've got clear and convincing, and you've got beyond reasonable doubt. So the judge said the state had proved its case by clear and convincing evidence, and that Emma was a child within the meaning of the 3A statute, and then went through all the ICWA procedures. That there had been proof that active efforts had been made unsuccessfully to prevent the breakup of the home, that there was proof of substantial harm to her if she was reunified with her family. And then on appeal, the Court of Appeals clarified that in an adjudication, so at the trial stage of the juvenile court proceedings, It's not clear and convincing evidence that we have to use, it's the easier standard. By a preponderance of the evidence. That's what we have to use to prove allegations, even in an ICWA case, at the adjudication level. And the court clarified that the only time we need to use that higher standard of care is when a party is seeking to effect a foster care placement of or termination of parental rights to an Indian child, and they pointed to the state ICWA statutes to support that. So that was a big deal for those of us who needed some clarification on the standard of proof. The warning piece comes in though, because in the original opinion, the Court of Appeals still reversed the adjudication order. And the reason they reversed it was because they said that the juvenile court in its adjudication order had said that there had been appropriate proof of active efforts and appropriate proof of substantial harm. But there was nothing in the appellate record that told the appellate court on what basis those findings were made. And so the court in its original order reversed the adjudication order with direction that Emma be returned to her parents unless that evidence was presented in the juvenile court. In a later opinion, there was a supplemental opinion filed in which the state had filed a motion for a hearing and basically said in the motion, oops, we forgot to include in the appellate record proof that the court had heard actual evidence in a lengthy hearing on all of those issues prior to the adjudication order, and had entered a specific order that outlined all the active efforts and the proof of substantial harm, and had done that before the adjudication hearing, and we didn't get that in the appellate record, so here it is. And the court said, we're not going to rehear this, but we would agree that there was actually evidence before the court to support these important findings in an ICWA case, and that the adjudication order was just a continuation of that earlier order. But it is a reminder to you, if you are the person, the guardian ad litem, the county attorney, the defense counsel, who's appealing or cross-appealing, you got to get stuff in the record on appeal. And it's important, especially in a case like this, you know, ICWA, active efforts and substantial harm, those are a big part of your proof, and you need to get that evidence up in front of the appellate court. And this was a unique instance in which the appellate court actually said, we'll kind of let that slide, and we'll keep Emma out of home, and we'll just assume that, you know, the earlier order was incorporated into the adjudication order. They have been known on occasion to say, you screwed up and didn't get your record, so go back and fix it. So it was, I think, an instance in which the importance of keeping juveniles permanent and stable won the day. Shayla H. is another case that involved ICWA, and in this case it involved ICWA, but in the original pleading, the initial juvenile court petition, the county attorney didn't actually include any ICWA allegations. And at the original adjudication, the father sought to dismiss the petition because there weren't any allegations related to ICWA. The juvenile court denied that motion, held an adjudication hearing, found that at least 2 of the 3 bases for a petition were met, that the evidentiary proof had been provided. And when the father appealed originally, the Court of Appeals said, you know, you're right. This case should have been dismissed, or the county attorney should have been forced to amend the petition prior to adjudication. So we're going to send this back. We're not going to look at the substance of any other issues. We're going to send the case back to the juvenile court with instructions that the county attorney be given the opportunity to cure the problem by amending the petition to include the appropriate ICWA pleadings or ICWA allegations inside the petition. And then, once that happened, the juvenile court said, you know, well, actually the county attorney and the folks on the side of the state's case said, we already had a full adjudication on all of these issues. We just didn't have the right language in our petition. So, juvenile court, would you please take judicial notice of all of the evidence and all of the testimony that was admitted at the prior adjudication? And the juvenile court said, that seems efficient and appropriate. We were all here before for all of that. The dad had an opportunity to cross-examine on all of that evidence, so I'm going to take judicial notice of all of that rather than asking the state to put that case on again. And then the juvenile court also gave the father the opportunity to put on additional evidence and to make his case. After that adjudication, where basically the judge just imported all of the evidence from the earlier adjudication, the judge again found that there was a basis for the allegations in the petitions, and the dad again appealed. And this time, the Court of Appeals said juvenile court handled it just right. It was appropriate to bring in all of that evidence by judicial notice because the parties were very clear about what evidence and what testimony, what exhibits were being brought in. In addition, they only asked for judicial notice to be taken of matters that were handled in the adjudication where the rules of evidence apply, and noted in dicta that perhaps if the court had tried to bring in evidence that was presented at a review or dispositional hearing where the rules of evidence don't apply, that might have been a problem. But they didn't do that. They just took the evidence from the adjudication proceedings, so that was okay. And then they said, the dad had an opportunity to present his own case. So even if that had been wrong for some reason, the dad had suffered no prejudice. And then in that same case, they reemphasized, as they did in Emma J., that the burden of proof at adjudication in an ICWA case is preponderance of the evidence, just like any other case. In Re Patience I is a very sad case when you read it, but when you hear the facts, it kind of takes the joy out of reading novels. It's one of those cases where, this can't happen in real life, and yet it does, and we all have those cases, where the facts are just so remarkable that you can't really believe that they're real. So here are the facts. Patience I's mom had suffered from delusions for which she was occasionally medicated. And the delusions were pretty significant. She believed that her ex-husband was a member of Hell's Angels. She reported on occasion that the Hell's Angels had raped her, killed her, and brought her back to life. She thought that members of the Hell's Angels were tapping her house and her kids to spy on her. And ultimately, those delusions escalated to the point where she decided that she was going to pack Patience up in the car and take her all the way to Washington, D.C. to ask the president to help her, to intervene for her. She got as far as Ohio when she came to the conclusion that she was being followed by a member of the Hell's Angels and that they were trying to run her off the road. And she did go off the road, and she was escorted to a psychiatric facility, and Patience was placed in a foster care placement in Ohio. On that very same day, here in Nebraska, the court entered an ex parte detention order, remanding Patience to the custody of the department due to her mom's alleged mental health issues. But Patience wasn't actually here. And she didn't actually get here for about 60 days. And when we finally got her back into Nebraska, Ohio transferred jurisdiction and Patience came back, then the juvenile court moved very quickly to get a hearing on that ex parte order and to get everybody in court. And that hearing happened within 2 weeks of her arrival back in Nebraska. So that time lag between the return to Nebraska and the actual hearing was only 2 weeks, very short. But the date of the ex parte detention order was about 60, 65 days prior to the actual hearing. And so the biological mother contended that that ex parte hearing, or that ex parte detention order, was inappropriate because it had taken so long from the date of its entry to the date of the hearing. And the court said, in what I think is a marked understatement, that due to the unusual circumstances in this case, which had largely to do with the fact that Patience was in Ohio and Ohio didn't give up jurisdiction immediately, they would not view that time lag to be unreasonable. Americall T is a great case, and here we go, for those of you in the trenches, if you want a little light reading and you actually like to read court cases, this would be a case to read. This is a really good case where the court sets out what kind of evidence is required to present to the court to show that a parent is or is not making significant efforts to work their case plan. So if you want some ideas about the sorts of facts that a court is looking for when you get up to testify, that's the case to look at. It's a really good case, and I'm not going to go into detail in that here, and I didn't do that in the materials either, but look it up and it's a good model. Cardale H is a great case, again, for illustrating the kind of evidence that is required in a case like this. You know, I think sometimes when we work in this area, you know, and I'd be curious to see if you all have, I mean, you sort of reach a point where you don't get desensitized to the difficulties of what you're facing, but you think you've just about seen it all. Anybody here think they've just about seen everything they could possibly see in relation to a juvenile case? And sometimes we get so used to dealing with these kinds of horrendous facts, these sorts of really difficult parent-child relationships, that we forget that it's not simply enough to have one more parent with a drug issue. You actually have to show that whatever that parent's issue is causing harm to the child who's the subject of the juvenile proceeding. And that's what this case illustrates. In Cardale H, this child, Cardale, was a toddler, less than a year old when he was pulled from the home. The basis for the adjudication hearing and the petition was that his father, while Cardale was in dad's custody, had 0.3 grams of cocaine in his possession. That was the allegation. And the juvenile court adjudicated Cardale as a child under 3A on the basis of that evidence alone. On appeal, the Court of Appeals said, whoa, everybody back up and take a breath for a second here. You don't have to show in a case like this that Cardale was actually harmed because his dad had 0.3 grams of cocaine in his possession. That's true. But you do have to show that Cardale, without intervention, would have been at definite risk of harm in the future. You have to show that there's a real likelihood that the fact that his dad had cocaine in his possession was going to result in his injury or harm. And you didn't do that. And the court noted in its opinion that there wasn't any evidence that Cardale's dad had been charged with a crime. There was no evidence that a sentence was imposed, that Cardale was impacted in any way because of the possession. You know, I had a case when I was a GAL where a toddler tested positive for crack cocaine because mom and dad left it on the coffee table, and he could pull himself up to stand, and you know, what's the first thing a toddler does? And you know, so he kept licking his hand because all the drug stuff was on the coffee table and he tested positive. That would be proof of harm. But they didn't have any of that evidence in Cardale. So, you know, it's critical to put on your evidence. And again, for those of you who are in the trenches day to day, we look to you to help us build our case. I mean, as long we have to be able to show that there's a real substantial danger for these kids.
Pam?
Yeah.
Do you think that's a problem for petitions that allege one or two specific occurrences, such as possession at one point or one instance of a domestic assault?
Yeah. Did everybody hear that? Judge Warden was asking whether this case would suggest that a petition that has just a specific allegation, like one instance of possession or one instance of domestic violence, if that could be a problem. And I think it could be, but I think it's fact specific too. I mean, if one instance of domestic violence means that mom almost died,
right,
that might be different than...
My concern from an evidential standpoint is if that's all it says, that's what the parent is there to defend in the complaint or the petition is the allegation. And for me as a judge, I'm wondering if this case says there's got to be more to find abuse and neglect than just that one instance. Even if there's more evidence, if those are the only allegations, it seems to cause a possible problem for those types of petitions.
I think you're right. I mean, you're going to have to be really careful. I mean, this case says you've got to be careful about how you plead and you've got to be careful about the evidence that you put on. If you skip ahead to number 10, that's in re interest of Christian L, and that's another illustration of how important it is to properly plead. You know, those first pleadings are really important. They're important for the judge because they give the judge guidance as to the basis of the allegations, but they're important for the parents too because they put them on notice of what they have to defend against. And in Christian L, the allegations in the petition were that mom had a dirty house and didn't provide food to the child. At the adjudication hearing, almost all of the evidence focused on mom's mental health problems, and the juvenile court allowed that to come in because the court said The allegation is essentially that mom wasn't taking care of the child, so she should know that her mental health issues would be on the table. And the Court of Appeals on Appeal said, no, 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 no. You never alleged anything in this petition that said mom's mental health issues were on the table. And because of that, the only thing we'll look at is evidence related to the dirty house and his nutrition. And the only evidence that was placed before the court said the child was actually in a clean and safe gated area, even though the rest of the house was kind of gross. He was in a clean and safe area when they pulled in, and he had good nutrition and was clean and was healthy. And so the court sent him back because there was a disconnect between the allegations in the petition and the evidence that was put on. And it may very well have been that he was not safe related to mom's mental health issues, but that wasn't pled in the opening pleadings. One other case I wanted you to look at just quickly, and we'll be about out of time. If you look back at case number 8, which is Appellate B, this is a case where the court re-illustrates the fact that bonding between a child placed in a foster care environment and that foster family can be a really important consideration for the court. And in that case, in Appellate, she was removed and placed with a foster family who had adopted her step-sibling, her older brother. And the evidence before the court was that she had bonded very significantly with that family as well as with her older half-sibling. That he took care of her, was protective of her, played with her every day. It was a very familiar place. After adjudication, the mom asked the court to transfer placement from this foster family to some friends of hers, who also, on the facts, appeared very appropriate. Had a home study done, were the placement for another sibling of Appalate's, had some Hispanic background that was very important to the mom culturally, and so they looked very attractive too. And the juvenile court said, you know, they do look attractive, I'm going to move Appalate over there. And on appeal, the Court of Appeals said, you know, this is a tough call because both the original foster family and mom's preference, they both look really good on paper. But we're going to move Appalate back to the original foster placement for 2 reasons. First of all, mom was with her choice on numerous occasions when she was using drugs and they didn't notice, which is sort of a problem from our perspective. But more importantly, the evidence is clear that Appalate had bonded with this original family, that she was very close to them, and that bonding was so tight that to disrupt it would not be in her best interests. So that's another case where the court said, let's look first at what is in the child's best interest, which would be the motivating factor, and the bonding relationship between her and the placement family is so strong that we can't disrupt that without damaging her best interests. So take a look at the other cases that are listed there. As I said at the beginning of the materials, this is not an exhaustive list of every juvenile case that was handed down by the appellate courts from September of last year to this year, but it does give you a good smattering of the cases that deal with some of the more technical or fact-specific issues that might be relevant to us. Thanks.